Hello, friends. I'm happy to share with you some of my thoughts on the topic of the session efficacy and future of data breach notification laws. Obviously, you are hearing or have already heard many experts from world over who have come to discuss the data breach notification laws as applicable in different countries, and you will also be comparing it with the position in India. My perspective would be mostly limited to the Indian scenario, but generally on the principles of this efficacy. Now, data breach notification is an essential part of data protection itself. You cannot protect data without knowing the information about the breaches which may happen from time to time, and therefore data protection laws will have to essentially provide for handling a situation of data protection. Same thing is also true in the scenario of cyber crime prevention. So therefore, in terms of efficacy, we must say and admit that data breach notification related regulation is essential and unavoidable in the context of data protection laws or cybercrime prevention laws. Now, this data breach protection regulation involves a couple of points, such as who has to notify the data breach, that is, who has to disclose, and when does he want has have to disclose, identify what data has been breached, whether it has been breached, and whether it has to be recognized as a requirement for the notification. If so, to whom? Should it be to the regulator or should it be to the data subject? And what exactly has to be disclosed? And should I disclose it immediately or after some time? And what will be the consequences if it is not disclosed? So these are the issues which normally come within the ambit of data breach notification law, which is part of the data protection regulation. Now, to understand the efficacy of this provision, we can look at our past experience, because India anyway has already put in place a data breach notification law through the Information Technology Act. Though the new act, Personal Data Protection Act, is coming up now, and GDPR came sometime back with its own influence on Indian scenario, ITA 2000 already has a provision under Section 70B which provides that the CERT-in has the right to demand information, including data breach notification. It has already issued a certain mandatory requirement of data notification, and CERT-in also has quasi-judicial powers which can prosecute a person who doesn't comply with its directions with an imprisonment of up to 1 year. So there is a provision already. Additionally, Section 79 of the Information Technology Act, which applies to intermediaries, also mandate the data breach notification to be sent to the CERT-in. So there is information on when data breach has to be notified, to whom it has to be notified, what has to be notified. All this is already present in India, and it has been present for quite some time, at least from the 2008 amendments, which in terms of rules came in 2011. So 7 years have passed. So we have the experience. But our experience of the application or implementation of data breach notification has not been very good. Therefore, it has been necessary for Reserve Bank of India to bring its own sectoral regulations. And despite the sectoral regulations of RBI and the ITA 2000, today data breaches do not get reported in to CERT-in, and we don't have proper records, and because of which we find it difficult to manage the information security at the national level. So there must be some reason for this. Now, we need to understand why companies or individuals are failing to comply with the data breach notification laws of ITA 2000. One is, of course, the ignorance of law. People don't know that there is such a requirement. The second is perhaps insufficient deterrence and implementation, because people know nothing will happen if they don't report. Thirdly, there is a possible backlash which people think would happen, and it will be self-defeating. That is, if a company which has been accused of data breach has to itself come to the open and say there has been a data breach in my company, it is more or less a sort of situation where they are committing harakiri, because their reputation will go for a toss. So there will always be reluctance arising out of a self-preserving attitude, which makes it difficult for data breaches to be notified. Sometimes there will be no policy regarding how to react to such a situation, so there will be something like an internal policy paralysis. But besides all this, there will be a genuine possibility that sometimes a company which intends to comply with also doesn't comply because of the inability to recognize the breach as having actually occurred in their organization. Because organizations are large and the information keeps flowing in at different points. Some information comes to a help desk person who doesn't know what is data breach, what is data protection law, and therefore he or she doesn't report it to the respective data protection officer or some other senior person, and therefore a data breach has happened in the company, but the senior persons do not know, and it doesn't get reported. So there are such genuine reasons also. So this ignorance or the inability to recognize, they are part of the awareness creation issues, but the reluctance arising out of the fear of backlash is something which is psychological in nature and which needs to be addressed. Therefore, if we are talking of laws which has to be effective, we need to design laws in such a manner that this fear of the data controller or the data processor to report a data breach to the regulator or the data subject has to be either completely removed or adequately addressed. One is, of course, disclosure to the regulator in confidence, which nobody has any objection. In fact, the companies would be happy to discuss with the regulator if expertise is available to find out whether the breach has happened, if so, how it has to be handled, and they would look at the data regulator more like an advisor rather than a person who is holding a stick to beat the company for the breach, either with a fine which is 4% of the global turnover, etc., which could kill the company there itself, or put the persons in jail and thereby make the executive's position untenable. But disclosure to data subjects also would be acceptable when a company feels that that such disclosure is necessary because some action has to be taken by the data subjects themselves. So both this disclosure to the regulator in confidence and disclosure to data subjects when action is required at their end would not be resisted by the companies. But when it comes to disclosure to public and media, there is a sort of a hesitation, because media particularly is known to misuse the information, twist it and make it TRP attractive kind of a thing, and definitely competitors will take advantage of that. So disclosure to the larger public space and the media is something which the law should ensure that it is somewhat done responsibly. And more importantly, the misuse by the media, by other members of the public who don't have a stake in the particular data breach, they should not be allowed to take advantage of the situation. This culture of having a PIL to the Supreme Court and objecting to anything and everything is something which makes any company hesitate in being honest. So, the law has to ensure that some kind of a protection is made available when a data controller or a data fiduciary, as we would like to call, comes up with a disclosure saying that I suspect something has happened in my company and there is a possibility that data breach could have happened, though I have taken all measures of due diligence. So, this disclosure with responsibility made to the regulator, like the Data Protection Authority, has to be protected in such a manner that adverse effect on the disclosing entity should be to some extent protected by law. Now, today, Indian law at least has taken this into consideration in the PDPA, which says that when the disclosure is made, the DPA will decide whether further disclosures are required to the data subject or not. GDPR to some extent is a little bit harsher. It leaves it as the responsibility of the data controller to simultaneously disclose it to the data subjects, and on a later date, if that is held as not done, probably administrative fines would be there. So, Indian law to that extent is better because it is asking the Data Protection Authority to take a call on the particular decision. At the same time, companies, when they form their data breach notification policy, has to ensure that when a particular incident is reported to the company, the input is immediately recognized as a potential data breach incident by whatever level the data is first recognized, and then it has to reach the DPO, that is the Data Protection Officer. Now, the Data Protection Officer should not immediately jump into disclosures. He has to first examine whether the disclosure is actually necessary, whether the data supposed to have been compromised is encrypted in data, or is it anonymized data, or a data which doesn't have the personal information and does not require a disclosure. That decision has to be taken by the DPO. Sometimes it is better if the DPO escalates it to a committee, including a board member, so that even at this time the board is brought into the discussions, so that the full impact of the data disclosure is recognized and immediate action is initiated. Sometimes the board has to take a decision to do some internal audit even before deciding whether a disclosure is required. So all this is possible if the policy provides for the DPO to escalate it to a level in which all decisions required can be taken, and then of course DPO will implement it because he has got a fiduciary responsibility to the Data Protection Authority. So this kind of law recognizing the potential for misuse of the disclosure and providing a certain protection to the honest disclosing party, and the internal policies of the company taking into account the need to involve the top management before a disclosure is done, are essential features which are required to be built into the future policies, which will perhaps enable better disclosure rates than what we see today. So, just to summarize, definitely data disclosure is an essential part of data protection and cybercrime prevention, but to make it feasible, to make people voluntarily comply with it, perhaps the law need to be made in such a manner that the honest disclosing party does not become a victim of further exploitation arising out of the disclosure. So friends, These are my views, which perhaps other people will discuss and debate, and hope my points will add to the points of discussion in the panel. Thank you.